We saw oral arguments yesterday in the Matthews v. City of Los Angeles lawsuit. This is a criminal suit dealing with CCWs, but potentially some larger implications for the Second Amendment movement. Let's talk about it. Hey everybody, welcome back to the channel today. It is a busy week with Second Amendment litigation. We have 3 oral arguments happening this week at the Ninth Circuit Court of Appeals. One of them already happened. 2 more of them are coming up on Thursday, I think it is. But the one that did happen, which is Matthews v. City of LA, I think is worth talking about. To talk to us about that today, we have brought back CRPA's volunteer president. That is Chuck Michelle. Chuck, thanks for being with us today.
Always a pleasure, guys. Thank you for having me.
Yeah, absolutely. And guys, before we get into this today, please, as always, be sure to like, share, and subscribe to these videos. Really helps push them out as far and wide as possible. We've got some stuff happening with litigation. It's starting to ramp up. We saw some SCOTUS stuff last week. This is happening in the Ninth Circuit this week, and there's a lot more to come. So we want to get this information out as far and wide as possible. Throw some comments in the comment section below. It really helps, whether you're trying to fuel the algorithms or if you got questions. We're going to try to address all sorts of stuff like that. So be sure to like, share, and subscribe. Chuck, let's do a little bit of pretext on this. Like I said, we've got 3 oral arguments happening this week. One of them already happened. This is the Matthews v. City of Los Angeles lawsuit. All 3 of these oral arguments that are being heard in the Ninth Circuit are criminal lawsuits. These are not the civil lawsuits that you're used to seeing CRPA or any other organization put forth. So I guess just as a preliminary question, Chuck, we've talked about this a little bit before. What's the impact that a criminal suit can actually have on something like the Second Amendment movement? Do we look for anything out of these the same way that we would a civil lawsuit?
It's a lot harder to win on a Second Amendment issue in a criminal case than it is in a civil case, because there's a lot of procedural hurdles that you have to get past in a criminal case. But because there's a case called Heck v. Humphreys, where if you try and attack especially if you try and do it as a separate lawsuit, if you try and attack a criminal charge, it's considered a collateral attack, and there's limits on that. First Amendment cases, there's a bit of an exception. There should be an exception for Second Amendment cases too, but the body of law is so new because Bruen just clarified this in 2022. But in the meantime, you don't want to have to litigate that side issue. That's the problem we get into with all these lawsuits, is the state wants to throw down a bunch of procedural stuff that wastes your time, costs you money before you get to the ultimate issue. Now, my understanding in Matthews is they were prosecuted a long time ago, before Bruen. Then when Bruen came down, they said, hey, that prosecution was unconstitutional. They filed a civil rights act against the LAPD in the city of LA, seeking damages for being prosecuted. And that's what the oral argument was last week. And this again came down to a argument about whether or not, in order to have standing, basically, to challenge a previous conviction, you have to have applied for a CCW and been denied. And that's an issue that came up in one of my cases 30 years ago, the William Masters case, where he was out walking one night and he came upon 2 taggers, and they went to attack him, and he shot both of them. One of them died. Then he was prosecuted for carrying without a CCW. And I made this argument that LAPD doesn't issue CCW, so it would be futile for him to apply. He wouldn't have been issued one. And that's the same argument now that the Matthews folks are basically making. They're saying we didn't apply because they weren't issuing permits. There were 4 permits out at the time of our arrest, and they were to like VIPs and LAPD officers. There was a LAPD police chief who came in out of Philadelphia. His name escapes me at the moment. But he couldn't pass the post exam because he didn't know all the California penal code numbers because he was from Pennsylvania. So the city then opened the door, gave him a CCW, one of the first ones in years and years, decades. And we sued, a number of other people sued, because now that's an equal protection violation. You're giving him a CCW, but you won't give anybody else a CCW. And he has no justification beyond what other people do because he has armed LAPD officers. He was the chief of the police. He has armed LAPD officers at his disposal to guard him at all times. So that did open the door for a short time for some more CCWs to be issued to the plaintiffs. But then a couple of years go by and LAPD revokes those CCWs. So this is the game that LAPD has played forever. They do not like issuing concealed weapon permits. They haven't issued forever. Bruen is forcing them to now to start issuing, but now they're playing the game of, oh, we don't have enough the manpower to process all the applications. Oh, and then there's a waiting list to just file an application. They won't even accept your application. And then there's a waiting list once they do to have the application processed. So they're ripe for a lawsuit. CRPA is getting ready to sue LAPD over this, just like we sued LA County Sheriff, just like we sued Laverne. We're getting ready to sue Santa Clara. Every time we win in any one of these jurisdictions, it carries over as a precedent in every other jurisdiction. So it's important to make some law in these jurisdictions that are dragging their feet or charging too much. And so that's what we're going to do. But in Matthews, what's probably going to happen is reading the tea leaves, they're going to remand the case back down to the trial court to do some discovery on whether or not they could have gotten a permit if they applied or whether it was futile to try.
Well, and they definitely addressed that with a couple of questions throughout the oral arguments. And guys, it's only about 25 minutes. If you want, check the link in the description below. You can watch it's about 20 minutes per side. You can go ahead and check out the entire oral arguments. The courthouse does stream this stuff on YouTube for future preference if you want to watch it live, like I got to. But they did kind of address that, and it seems like the plaintiff's arguments ended up being that there was clear messaging on the LAPD website, basically stating that permits were not being issued. So definitely curious to see that. But ultimately, what we look for is nuggets, right? We look for any kind of precedent that may be able to help in other Second Amendment litigation. And I'm going to ask for your take on this, Chuck, because I certainly felt like there was a little bit of a nugget here. We do have a clip from the oral arguments. Jacob, why don't you roll that right now?
That definitional authority, why, I come back to, I don't understand the argument about why they couldn't make a Second Amendment challenge without bringing a larger challenge to the whole statutory scheme.
Because they weren't arrested for violating a city policy or violating a municipal ordinance.
They were, though, right? Because the state law says you can't have a weapon. And that says unless you have a license that's issued by the local government. And then the local government, they allege, will not issue a license. So we have to read all three of those laws together.
Well, but they could have brought a pre-enforcement challenge. They could have, even if they had never applied for a license.
But here there was enforcement, so they're not in a pre-enforcement situation.
They got arrested. That's what
Right.
triggered it. This isn't the NRA bringing a suit. I suspect there may be support elsewhere, but they got arrested. They've suffered an injury. They allege they suffered this injury because their constitutional rights were violated. Why can't they bring that cause of action?
Because they're not challenging the state statute.
Why do they have to challenge the state statute? It was a statute that turned authority over to make the decision to the local police chief. Maybe in this case it was the Board of Police Commissioners. I don't know. I mean, LA has structured it in a certain way, and that's fine. LA has the authority to do that. But if it was LA that decided to have a policy, we're not going to issue them unless we think they're really necessary, that is, the judges, law enforcement, people under threat, and so forth, then these people contend at the stage of a motion to dismiss they wouldn't have qualified. Why does that justify dismissal at this stage?
Because they were arrested under They were arrested under state law, not for, the charge wasn't, violating an LAMC code or violating the CCW policy. They were arrested under
Who were they arrested by?
LAPD.
That's the reason that LAPD is the defendant. Now, let's take an easy one. I'm going to leave aside the limitations issue for a moment. Mr. Matthews is from Tennessee, so as I understand it, he couldn't have been issued a permit because the permits were limited to residents. Is that correct?
Right.
So how can the state or the city or the arresting officer decide to limit constitutional rights to people who live there? I mean, Judge Forrest and I travel here. Does that mean we don't have any constitutional rights because we don't actually live here, so we can't speak out? We can't exercise religious rights here because we don't live here? No state, no municipality can condition constitutional rights on being a resident of that municipality.
Well, the state, Your Honor, I'm sorry.
So I'm having trouble understanding. It's sort of like people are pointing fingers. Sue the state, sue the city, and so forth. If you put all the pieces together, these people got arrested by officers of the city of Los Angeles. So you can argue, but I don't understand how that's a basis to dismiss the case.
So, Chuck, I got to ask, he was pretty direct with his statements there, and I don't really see how you can't find this as an argument for reciprocity. Is this kind of what he's leading into here? What's your take on this?
Well, I think there's a question of interstate reciprocity. But remember, reciprocity means you have a permit from another state and it should be good in California, as opposed to you have a CCW or you're traveling in another city in California and you don't have a permit and then you get arrested in Los Angeles. So I think the judge was basically saying in a broader strokes that you can't require someone to just because they're not from the city of LA, you can't require them to have a permit from the city of LA, just like you can't require them to have, a free speech permit from the city of LA to speak in LA. So I'm hopeful that judge kind of gets it and will be one of the ones who votes to remand it back down to the trial court to develop this futility argument and show that LAPD wasn't issuing these permits. And so they shouldn't have been able to be charged for not having one.
Well, you would think that the chances are greater than otherwise it could have been. I think two of those judges were put in there by President Bush when he was in office, and the other one was put in there by President Trump. So definitely pulling a little bit of the lucky straw there when the Ninth Circuit seems to be about 60-40 right now, just by appointments by Democrats or Republicans to get all three. Can't hurt you. It certainly can't hurt you. I guess, final thoughts, Chuck. You got one oral argument down. You've got Metcalf coming up on, I believe it's Thursday. It's either Thursday or Friday. You've got Metcalf coming up, which is a sensitive places case. You've also got Kitson coming up, which is I think that's a machine gun case, right? Ultimately,
CRPA has done amicus briefs in all those cases.
Yeah, and ultimately, we look to help on the Second Amendment angle. Looking forward, what do you see potentially coming out of this and helping with other litigation?
Well, it depends on the language, and it depends on whether or not the holy grail that we're going for still is something that correctly applies the Bruen test. And they did that in the Duarte case on nonviolent felons, but then they sucked it up to an en banc panel and vacated that 3-judge panel. That's the game the Ninth Circuit keeps playing. So on some of the smaller issues where the Bruen methodology really isn't the main issue, we can get some wins out of these. But until the Supreme Court clarifies exactly how you're supposed to apply the Bruen methodology, that arms aren't limited to certain arms, they're all arms, that includes full auto, that includes magazines, that includes parts, that includes suppressors. They're all part of the arms, and it's not just the hardware, it's also the associated conduct. So going to the range, getting your gun repaired, participating in marksmanship contests or recreational shooting for that matter, hunting, all of that goes along with the right to keep and bear arms. And then the second question is whether or not there's some indication, because there's a historical law that's similar to the modern day law that telegraphs that the founding fathers, when they wrote the Bill of Rights, would have tolerated the modern law. That's not what the courts are doing. They're trying to exclude as much hardware and as much conduct as they can from even being covered by the right to keep and bear arms language to begin with. And then they're stretching the historical analogs so that a Bowie knife law justifies a semi-auto ban. So we need the Supreme Court to get back involved. And interestingly, there's two cases that the spotlight is now on that the Supreme Court will be hard pressed to not to take. One of them is the Duncan case, the magazine capacity case. There's been 2 trials on that case. And now there's the Illinois semi-auto case, which is going up to oral argument within the next few months. The briefs are in the process of being submitted now. We just submitted our briefs on Friday. So the state now has to submit their briefs, and then there'll be oral argument. But those cases both have complete trial court records, expert testimony, documents, exhibits, witness testimony, live and recorded. It's a full record. That's what the Supreme Court seems to have been looking for, and seems to be looking for to take a Second Amendment case. We really need that to happen. But the Duncan case and the Illinois case now seem to be at the front of the pack.
And always a lot to look forward to and to support on that end. I got to tell you, it was pretty refreshing to watch a 3-judge panel at the Ninth Circuit seemingly get it and at the very least understand constitutional rights enough to ask those sorts of questions. Again, guys, watch the video. It's in the description below. And put victory, 2-way victory in the comments section, you guys, if you're watching this and you're thinking that the judges are understanding what's at stake here. It's very important. A couple more oral arguments coming up at the end of the week. We'll certainly be hitting those. But Chuck, I know you're a busy guy. Thank you very much for coming on and sharing with us.
Thank you for having me, fellas.
Absolutely. And guys,
CRPA, support the cause. Be a part of history.
Absolutely. And guys, one more time, if you like these kinds of videos, you like the content, you want to see them get pushed out there, please be sure to like, share, and subscribe to them. It really helps with the algorithms to push it out as far as possible. We're trying to keep the 2-way ball rolling here in California. Thanks again, guys. We'll see you on the next one.